Hi, my name's Heather Reynosa, and I'm one of the partners at MPL Law Firm in York, Pennsylvania. My primary practice area is in the domestic field. I help a lot of families and hopefully a lot of individuals with their personal and family matters. And today I am talking to you about termination of parental rights as well as adoption. And those are very, very important rights for a family, and it's a very important and emotional sometimes proceeding. As far as the termination, there are two types of termination in Pennsylvania. One is by consent. So in that scenario, we have a family, and for whatever reason, one of the biological parents normally has said, it can be both, but one has said, I don't think I am the best person at this time to raise my child. And it's a really difficult decision. I can tell you it's probably one of the most unselfish decisions that somebody makes. It's not an easy one. But when that happens, we can terminate the biological parent's rights by consent, which means by agreement. And that's usually and hopefully an easier process as far as the court proceeding. And so we would go into court with documents that are called consents, and we would terminate the one or two biological parents' rights to the child or children, and then we would have two individuals or one, depending on the circumstances, adopting. The second type of termination of parental rights is the involuntary, and that is more litigious. And the reason for that is you usually have one or two biological parents who are saying, I don't want my rights terminated to my child or my children. But for very serious circumstances, they need to be. The goal of adoption, and along with that termination, is permanency for the child or the children. And that's to give them the best chance to succeed as they grow. And so in that case, we're going to have a litigation proceeding, and we're going to be having to prove, which we should, by clear and convincing evidence, that the rights of the biological parent or parents should be terminated. And if the court grants either the consent when it's voluntary or the involuntary termination, then there's an appeal period that will run, and that will be 30 days. And once that 30 days has run and there's no appeal by that terminated parent or parents, then that is final for all time. And what I mean by that is when we go to the next step, which would be the adoption, there is no longer that biological parent. They don't exist under the eyes of the law. So it's a very serious proceeding, as it should be. It's a very important proceeding. It's the tougher part of the two proceedings. So I always tell my clients, we get through the termination, the adoption is the nice part. The adoption is then where we go, same judge, and you always have a hearing. And in that situation, the child should be present, whereas in the termination, they normally are not. If a child, I think it's 12 or older, if they are that age, they actually have to participate in the proceeding. And they will have legal counsel, or they'll have legal counsel and a guardian ad litem. And so then we have the adoption hearing. Again, this is the happy event. We usually can get permission to bring in a camera to the courtroom. The parent, like let's say we have one parent adopting and the biological parent remains. So there's one biological parent and one adopting parent. So we'll have both of them testify. If there would be two adopting parents, we would have both of them testify as well. The court would hear from the child if appropriate and old enough. If not, then legal counsel or the guardian ad litem is going to help us with the child's opinion. And at the end of that proceeding, normally the court is going to grant that adoption. And then we're able to take pictures with the judge. Grandparents sometimes come, aunts and uncles, friends. Usually it's somewhat a celebration. So that's probably one of the happiest things I get to do. The other thing that goes along with the termination and adoption that's really important is usually the parents wish to change some portion of the child's last name. Many times it's just the last name, and that's fine, but you actually can change the entire name of the child. And again, depending on the circumstances, the age of the child, how long the child's been identifying with their name, you may or may not want to change, their entire name. And so then I would say it's really important to have an attorney in these types of proceedings. I would not want to go to either one of these proceedings without counsel, even though I am a lawyer. I would still obtain counsel. It's very complicated. And again, the burdens are very high, as they should be. But clear and convincing evidence is probably the highest burden in the civil realm. So it's very important. The court takes it very seriously, and you want to get it right. So if we can help you in this matter or other domestic matters, please don't hesitate to reach out to our firm. And again, my name is Heather Reynosa, and I work at MPL Law Firm. Thank you for your time.